Good morning, everyone, and a very warm welcome to all our TESD members and their guests, as well as our EXCO colleagues, including our partners from the CEA and CIFSA, for joining us today for this webinar. It's wonderful to have you for this session, which is a topic that's truly hot on the labour horizon, which is the employment of foreign nationals, particularly within the TES environment. A special welcome to our presenter, Natalie Singer from Global Business Solutions, who will guide us through the key areas shaping this decision. If you don't know Natalie, you should start to get to know her. From legal frameworks and compliance to work permits, as well as dismissal procedures, the TES specific considerations and updates on DOL and SAPS operations. Natalie, thank you for joining us and helping to unpack some of the great areas and the grey areas around this important subject. Please feel free, if you have any questions during this session, to drop it into the chat box. Natalie will address them at the end of her presentation. And then just a quick note, this webinar is part one of our focus on the employment of foreign nationals. We will be hosting part two on the 12th of November, which I think Natalie can just elaborate a little bit at the end of the webinar what part two will be focusing on. We will dive deeper into the practical and legal aspects. We look forward to seeing you there too. So enjoy the session, everyone, and thank you for being a part of this.
Thank you so much, Lisa, and it's an absolute pleasure to be with you, your members and their clients today. My name is Natalie, as Lisa pointed out. I'm an executive consultant with Global Business Solutions, and part of my responsibilities have been supporting clients through a range of changing landscapes. We, of course, did the whole COVID-19 TERS issue, and what happened as a result of COVID TERS is that in the process of making applications, of course, we realized there were gaps in the UIF systems around handling foreign national employees, for example, which necessitated the requirements for companies to go and manually capture them onto the U-filing system and others. And what I think that did was it did also create a little bit of a trigger and a wake-up call for the department, of course, UIF being part of the Department of Employment and Labour, realizing just how many foreign nationals are in fact employed. There are, of course, a myriad of different factors influencing the current landscape around foreign national employees. And so we've seen a lot of noise in the media, some of which, of course, positive stuff that are making changes, and of course those that are not so happy in relation to Operation Tadula and some of the others. So as Lisa pointed out today, what we're going to do is we're going to be taking a really sort of a big picture look at the current immigration landscape, and then looking at the various components of it. So we'll talk a little around the Department of Home Affairs, which of course has a new minister under the Government of National Unity, and where we have seen some positive moves forward. So it's not all bad news, but of course there are still some challenges. And what does that mean practically for individuals who are kind of stuck in the system, and for you as employers potentially of those individuals? We heard last week of the further extension of the ZEPs. So we're going to unpack that in more detail, and specifically looking at what exactly the ZEP is. I think there is a little bit of confusion in the market, perhaps some assumptions that all Zimbabweans are covered, and that's certainly not the case. And so as an employer, it's very important for you to understand who is and who isn't covered and what it means from a practical perspective. We're then going to look quite practically. So I'm not an attorney. I work with some very brilliant attorney minds. So if ever you need to tap into the brilliance of attorneys, you can certainly do that by working with my team, but certainly try to understand the legislative framework from a practical perspective. So there are a variety of pieces of legislation, of course, most specifically the Immigration Act, the Employment Services Act, which create obligations for employers around the employment, particularly of foreign nationals. We're going to look at what those obligations are and how you need and what you're expected to do in terms of due diligence, what the consequences for non-compliance are, and they are quite serious. And then, of course, just some practical compliance stuff, which I would like to challenge you at the end of this, if you haven't already done it, to go and have a look and do some due diligence internally to see where you might have some gaps. When we come back in part 2, the thinking at the moment, and I'll be happily guided by what you want as well. So please do pop those questions in or post comments, concerns, and we'll address them obviously as we move forward today. But that will also give us some guidance on what kind of content you want to see for part 2. But the thinking also is around helping to look more practically at the sort of legal and technical aspects of what happens if you have a raid. We've seen an increasing number of raids and including arrests. We've had frantic calls from some of our clients where HR managers and or production managers are in the process of being handcuffed and put into the back of police vans and that sort of thing. So what does that mean? What do you need to know? What are your rights? How do you make sure that you're doing the right things? And of course, protecting yourself and protecting the business. And then, of course, I've left plenty of room in the session for Q&A. So please do pop your comments in the chat. Lisa, I'm going to ask you that if there are any questions, burning questions or clarity as we go forward and someone wants to pop their hand up, they're welcome. The challenge with Microsoft Office, Office Teams, is I can't see hands when I'm in presentation mode. So I'll need to be guided by you in that regard.
Perfect. Thanks, Natalie.
Okay, excellent. So let's just start at the beginning. As they say, it's a great place to start. And who is a foreign national? Now, this is a little complicated because it depends on what we're talking about. So there are definitions that sit within the Immigration Act, the Employment Services Act, which of course are the ones that we are focused on for the purpose of today's webinar. But we also know that employment equity is a hot topic, as we've all been grappling with getting our sector target plans. And there is, of course, the concept of a foreign national within employment equity, which differs from that under the Immigration and Employment Services Act. So let's start with the Immigration Act. So the Immigration Act is very clear in saying that a foreign national is defined as any person who is not a South African citizen, which means that you were born here, essentially, or at least one of your parents was born here, so you're a citizen by descent, or who is a permanent resident of South Africa. Now, that can be people who are here legally. Okay, so foreign nationals can be legal in that they are here, they are documented, they are here under a specific visa or permit. Of course, that doesn't necessarily mean work. I mean, it could be somebody who's here traveling on holiday, as an example. And then there are those who present themselves illegally to claim, for example, asylum. And then, as we know, we have a large number of undocumented illegal foreign nationals in our country because essentially we have extremely porous borders. And so it's almost impossible. Some of you might have seen some of those pictures, which is insane, where, for example, in Lesotho, you've literally got a street, and on this side of the street, it's Lesotho, and on that side of the street, it's South Africa. And children who live here walk across the road and go to school in South Africa. Similarly, in Swaziland, also landlocked, as we know, there are very, very loose arrangements in terms of how people are working and walking and moving around. So citizenship, an individual is not a South African citizen, is of course a foreign national. A permanent resident is someone who has been issued with a South African ID and essentially given the right to live and work indefinitely in South Africa. Now, of course, permanent resident status could be revoked in the event that somebody becomes an undesirable individual, but a permanent residence gives people the opportunity to function within South Africa. The legal status, of course, depends on how long you are here and whether you're authorized or not. And then refugees come under a completely separate category. We have the Refugees Act. South Africa is a member of the United Nations. It is a member of the International Labour Organization. And under the United Nations specifically, we have obligations as a member state to take really, we can't refuse anyone who presents themselves seeking asylum. There are processes, of course, that need to be followed in terms of assessing individuals and moving them through the asylum seeker phase into essentially a refugee phase. And if they are a refugee, of course, they are then entitled to remain within South Africa. We then have the Employment Services Act, and that defines a foreign national in kind of more simple terms than the Immigration Act. And it simply says that it is any individual who is not a South African citizen or who does not have a permanent residence permit or who has not been granted recognition as a refugee. Now, please just be very clear, an asylum seeker and a refugee are not the same thing. So a refugee would be in possession of a refugee's ID, essentially. To my knowledge, they are maroon. I haven't seen one myself physically, but that's my understanding. Permanent residents, refugees, and South African citizens, of course, are free to live and work in South Africa without restriction. On the employment equity side, the Employment Equity Act, although it doesn't specifically define a foreign national in its definitions up front, it's very clear when it talks about designated group members who are or who aren't designated groups. And designated groups discount anybody who is not a South African citizen by birth or by descent, which means essentially that someone who is a permanent resident, so they have a green ID book, but they are not a South African citizen, is not counted as a designated group member. Now, they don't have to have a work permit, so you can freely employ someone who has a green ID book as a permanent resident. But when it comes time to reporting them for employment equity purposes, those individuals must be reported in the columns of foreign national. So whether they are from Ghana, whether they're from Iceland, whether they're from Swaziland or Australia is irrelevant. We don't demographically describe them in terms of race or origin, only differentiating on gender, and they would be classified as foreign nationals for the purposes of employment equity. Now, how do we tell the difference? Because those are individuals who have an ID number. So for those of you who may know, I'm sure we're all familiar with that, the first 6 digits of our ID number is our birth date. We then have a series of numbers, there are 4 of them, which give indications of a variety of things, our province of birth, etc., but also does give an indication of sex. And again, this is a complex issue when it comes to the issue of gender identity, where we're talking differently if we're speaking about diversity, equity, and inclusion in terms of how we can be accommodative of individuals who are, for example, non-binary or transgender. But for the purposes of employment equity reporting, we must report according to their registered sex, which would have been registered at birth. And we can tell that from the 7th digit in the ID number. So the first digit that comes after our birth date indicates essentially sex as was registered at birth. So 0 to 4 is female. 5 to 9 is male. It's usually at this point that everybody's going in their head quickly looking, am I correctly registered? So that'll give you an indication of sex. But in the purpose of what we're talking about today, it's the 3rd last digit that will help us to know whether an individual is in fact a South African citizen or if they are a permanent resident. So the 3rd last digit, if it is a 0, as is the example on the screen here, 082, or in my case, 085 in my ID number, I am a South African citizen. Now, of course, as a South African citizen, free to live, work, any who and how, I would be a member of a designated group as a white female. If I had a 1, so 182, 181, the 1 would indicate that I am a permanent resident. So I've been issued with an ID number. It could also be the same for somebody who's been issued with an ID number as a refugee, but I'm not a citizen. So where it is a 1, 182, 183, 184, that is the clue for you to be able to report them under foreign national in the employment equity reporting. If they have an ID, they're eligible to work. Okay. Right. So let's dive into kind of where we are in terms of the current immigration landscape. And I think many of us have seen this. We hear it almost daily on the radio and on the TV, that at the moment there seems to be a very strong anti-foreigner sentiment in South Africa. Whether we go as far as speaking about xenophobia, some of us may recall some years ago, we had a horrific period of time in South Africa with very serious xenophobic attacks taking place in areas of our country, and hopefully we're not going to see that happening again. But we've seen a rise of various movements which have brought forward this anti-foreigner sentiment. it's a conflagration of factors, not least of which is the continuing escalation of unemployment in our country at excessive numbers, particularly for youth. There is a large scale of frustration and desperation among South Africans who are struggling to find employment and, of course, are finding themselves in situations of poverty and impoverishment. And so it's very easy to look and say, well, how come there is a foreign national taking a job that I, as a South African, should be given the right to? We saw and continue to see the issues within the trucking environment, the logistics, road logistics environment, where there is a very anti-foreign driver sentiment. Again, you know, the belief that the reasons that companies are hiring foreign nationals is because they're cheaper or they're prepared to work hours longer than is allowed. And again, I would hope that that's not the case, that employers are being compliant. I learned for myself, I'm certainly not somebody who's worked in the logistics sector before. I was part of the business delegation at the recent National Labour Migration Policy Dialogue that took place in Pretoria. And it was at that session that I actually was chatting to someone who explained that one of the challenges that companies are having is that the South African truck drivers' licenses do not allow them to cross the border without all kinds of permits having to be applied. Whereas the same is not true of our neighboring countries' drivers, who can very easily drive cross-border with no issues. So, of course, from an operational perspective, a cost perspective, and a time perspective, it makes perfect sense that companies, particularly those logistics companies who do cross-border transportation, would choose a foreign national driver with a foreign license because it makes more sense. So that, to me, speaks more to an issue of policy within our local environment, which perhaps needs some work. But of course, that's not necessarily understood or explained on a practical level to those drivers who feel that they're being left out in the cold. We've also seen the rise of organizations such as Operation Dudula, which has a very militant approach, a very aggressive approach. And, you know, we've heard terrible stories recently of them blocking, and not just them, but of course people who have been egged on as well, blocking schools, blocking access to clinics and others. And again, can we blame people when I'm reliant on a state entity to go and get healthcare, and I arrive and there are no nurses, there is no medication, people are sleeping on the floor? It is very easy to get frustrated in the assumption that people who are not South Africans are taking resources which are already limited. Now, of course, any individual who is in our country has a right to access healthcare. They have a right to education. They have a right under our constitution to a variety of other things. But it's this issue that we have of, we've seen the Tembisa hospital capture and everything else coming, this ticking time bomb, which is creating increasing uncertainty, increasing frustration around foreigners, and they become a very easy target. So certainly it's not true to say the analogies that all drug dealers are Nigerians, and that all spaza shops are owned by Somalians, and that all hairdressers, you know, barbers are Pakistanis who shouldn't be here. We make these stereotypical assumptions. It's very easy to point fingers and to create discontent. What this has translated to, unfortunately, is, of course, increasing unrest in environments of potential for violence and other issues. And this is weighing very heavily on all of us as a country, and certainly for the government as well. Within this context, of course, we need to just have a look and see, well, how many foreigners are there? And this is a question without an absolute answer, given that we don't actually know exactly who is in our country. So the Statistics South Africa does census on a regular basis. However, it is not necessarily accurate. Not everybody is going to come forward, particularly undocumented. But what is interesting to see is when we look at some of the statistics and we compare sort of 11 years on from 2011, which really was at the height of all the unrest and political disruption within Zimbabwe, where we started seeing a mass migration of Zimbabweans coming across our border as a result of the political upset and the infighting that was happening at the time. And you can see that in 2011, Zimbabweans made up the largest proportion of the foreign nationals, at least those that had declared themselves in the country, at just under 700,000, followed closely by Mozambique and then Lesotho. So unsurprising, our most immediate neighbors. Fast forward to 2022, which are the most recent statistics available, we can see that the number of Zimbabweans has increased, almost doubled, in fact, to just over 1 million. The Mozambican population has been fairly consistent, and although the Lesotho population has also doubled in that time. We know historically as well in South Africa, particularly within the mining sector, we saw a lot of intentional migration or bringing in of foreign laborers into the mining sector as migrant workers, and that continues in those sectors. We see in the agricultural sector as well a large proportion of foreign nationals used. And again, not intentionally. I know working here in KZN with the sugar industry, it's a frustration for many sugar farmers. They would like to have South Africans employed, but they have difficulty in convincing South Africans to work during the cane cutting season. And of course, cane can't wait to be cut. And so without adequate local individuals willing to work, they often are then resorting to corporate work permits to bring across, in particular, Malawians and Mozambicans who will come over on seasonal permits to come and cut cane. I think similarly in environments like in Mpumalanga and Limpopo, also then bordering, of course, Zimbabwe, very often a similar situation arises where local environment or local laborers are not willing to work. Again, we can have the debate around, is it because of wages, and not suggesting that the foreigners are paid below what is agreed, but whether South Africans think it's worth it, the effort for what is being offered. Very often then find foreign nationals in the agricultural sector. We know that the vast majority of immigrants in South Africa, of course, from the SADC region, so our immediate neighbors. But when we look at the African continent as a whole, which is where the majority of our immigrants come from, we, of course, do have immigrants coming from other parts of the world too. The vast majority are coming from Africa, and South Africa remains the top destination in Africa for labor migration and other economic, political migration, etc. So globally, USA, UK, and Germany are the top global destinations, but certainly South Africa is the USA of Africa, if we can put it as colloquially as that. In the middle, I just thought to share with you, if we have a look at the most recent transformation report, which was issued by the Department of Employment and Labour, what we can see there is it's pretty consistent that foreign nationals are making up about 3% of the South African workforce. What is interesting to see too is that it's fairly consistent through all the occupational levels. So whilst we might have expected to see a concentration of foreign nationals in the sort of professional skilled levels where we know we have skill shortages, that horrible dichotomy between mass unemployment but also chronic skill shortages. You would have expected the concentration there, but we see that 3% pretty persistent, even down into semi-skilled and unskilled occupational levels. That does cause frustration for the Department of Employment and Labour and other governmental organizations, as I'm sure you can understand, because the assumption there is, why would employers not choose to hire a South African when there is an opportunity at a fairly low level of skill within the organization? It's not a case of, somebody having a specific qualification, etc. So I feel pretty comfortable in making the assumption that at least within sort of the formal sector, we're probably looking at a 3% foreign national contingent within the South African workforce. Now, obviously, there's lots of information on these slides we're going to share with them, but really just to give you an idea, we think that we're unique. We certainly are not unique. So labor migration is a reality in the world today. These figures come from the International Order of the Labor Migration, which is a portion of the UN. And what we've seen is that in the space of just 10 the total number of migrants, and the way the definition works is somebody who is living in a country that is not their country of birth. Now, of course, we know people move for many different reasons. We have mass immigration from South Africa as well, as we know. That's more than doubled. So in 2007, 2008, there were about 130 million people around the world who were living in countries that were not of their birth. Today, that's figure, well, in 2020, that figure is sitting at above 280 million. So it is the norm. If one listens to the research and the engagements at an ILO level, at a UN level, at an IOM level, particularly in more developed markets, it is assumed to be a well-functioning labor market with about 10% foreign nationals, which is interesting. So we've got 3, which is problematic in terms of policy, but about 10% is seen as a pretty good number for a well-functioning labor market, recognizing that we have mismatches of skills, we have demographic shifts around the world, which means we have aging populations in some environments, which necessitates bringing in young people from different parts of the world. Of course, many people are migrating for economic reasons, not necessarily just political persecution, although of course we know that there are, but the vast majority of migration happening in the world today is as a result of seeking better opportunities economically. And South Africa is not any different. Of course, the challenge we have compared to environments like Europe and the US, which have extremely low rates of unemployment, we have high rates of unemployment, which of course creates the political challenges. And so the government has been tasked, and they've been working on this for some years. I'm very proud to say that we work with some incredible people doing incredible things, as I'm sure you've heard in other webinars on many different forums, one of which is Bev Jack. She's an executive with CAPES, on the CAPES Manco, and she serves on the Employment Services Board together with Jonathan Goldberg and Elias Menahi. And they've been very, very instrumental as business representatives in working on the National Labour Migration Policy. And this is this careful balancing act that government has got to try and manage. How do we retain our competitiveness as an economy by ensuring that we have skilled, motivated, and productive workers, that we have a labor market which is future fit and recognizes transient skills, the need to bring people, multinational organizations, and everything that goes with that, in an environment where we have such high unemployment, where we have poverty, and everything that is necessary to achieve social justice. And so if we look at the vision of the National Labour Migration Policy as is articulated, it says its purpose is to give rise to effective and efficient government leadership and intervention supported by the social partners and major stakeholders to allow for safe, orderly, and regular migration for the employment of highly, semi, and low-skilled workers to and from South Africa in pursuit of the country's national priorities. So there is recognition that it is not just high skills which are required. If we think about, it's not just about inbound migration either. One of the areas that is currently being explored in bilaterals between Department of Employment and Labour and other countries like, for example, Ireland, is around the export of skills, particularly young people from South Africa. A similar project has just been undertaken in Kenya, where Germany has a shortage of bus drivers. So they have, of course, what is known as full employment. So essentially, pretty much no unemployment. People who are unemployed choose to be so, for whatever their reasons are. And they don't have enough young people, and they need people to drive buses. And so they have partnered with Kenya. They came across to Kenya. They recruited, I think it was 2,500 young Kenyans. They put them through the training. They licensed them. They helped them to learn German. And essentially, those are individuals who are now working in Germany regularly, properly managed in terms of permits and, protections in terms of labor protections. And that's money, of course, well, one, young people who were previously unemployed or are now employed, and of course money coming back into the country. This strategy has been one that Thailand has had for many, many years. For example, overproducing quality welders and nursing and healthcare professionals far more than their own systems require, so that those are individuals who can go out into the world and who are providing a needed skill elsewhere, and where they, of course, will be helping to support their own families back home by remitting funds into the local economy. So these are some of the things that are currently under discussion, quite high, forward thinking in many ways. So certainly I know that from a business perspective, it's very easy to sit back and assume that it's the negative stuff coming at us, but certainly looking at how do we achieve this balance. Part of the changes, which is going to enable the National Labour Migration Policy to come to its fruition, would be the achievement of amendments to the Employment Services Act. So the Employment Services Act came into being just more than 10 years ago, and it does include a section around the employment of foreign nationals. Now, the proposed amendments seek to limit how many foreign nationals can be employed by certain employers or certain sectors. Now, of course, it aligns with other pieces of legislation, which is very clear to say that you may only employ foreign nationals if you do so in line with the Immigration Act, the Refugees Act, or any of the other legislative provisions. And that we as the employer are sure that that individual is entitled to work in South Africa, that their permit allows them, and that aligns with the role that we're seeking to fulfill. But it also places an obligation, a legal and moral obligation, on us as employers to say we should be operating from a South African's first perspective. So can we only look to employ foreign nationals if we are unable to find a suitably qualified South African with the requisite skills to fulfill that vacancy? Also making provision for skills transfer, again, as part of the intention to reduce our reliance on external skills. And of course, reinforcing the fact that foreign nationals must be treated fairly, and they must receive all the same terms as local workers. Now, of course, we know in practicality, and certainly for those of us who employ high-skilled individuals, critical skills people, very often we're having to pay them a lot more to bring in an expat into South Africa. So it's not about not paying more, but it's certainly about protecting on the low end, because again, there is this belief, whether real or perceived, that the reason employers choose foreign nationals is because they work for less, and that they, are not going to report poor working conditions, etc. Now, what it also does is it allows the minister to establish quotas in particular sectors. And this is something that I know created some consternation. We know that certain sectors are targeted in this space, those that are perceived as having a disproportionately high number of foreign nationals, things like agriculture, construction, hospitality are just some of those examples. Right, so let's have a look at the key categories, because there are a multitude of them, and we're going to focus obviously today on the ZEPs, and then looking at those kind of the general ones that you would likely to be coming into contact with. We have those who have right to remain, and right to remain would be permanent residents and refugees, those with IDs. So remembering right to remain essentially allows them to be treated in the labour market the same as a South African. No requirement for a work permit. They can be employed in any way, shape or form, obviously in compliance with all normal legislative and collective bargaining requirements, and they can move freely in the labour market. We then have others, and I've just put others in brackets, and I haven't included detail on them for today's session, but if you are interested, because this is something that you come across, happy to incorporate it into part 2. But we have those who are asylum seekers, so essentially they are still in the process of being assessed Asylum seekers should not be on a never-ending story. Unfortunately, with backlogs, we do see that. But theoretically, an asylum seeker should be assessed and either sent home if they do not meet the requirements, or converted essentially into a refugee if they do. We know that in the context of South Africa that is not happening as efficiently as it should. Just a note on asylum seekers, they do not have an automatic right to work. So you are required to review the documentation to see whether it has been endorsed to work. We note that very often they are giving them the right to work because they would rather that they have the means to support themselves than for government to be responsible for them, because they do take responsibility for asylum seekers as soon as they are in the country as part of the UN responsibilities. Spousal visas, now I've put it in inverted commas because it isn't actually a specific visa, but it's an 11(1)B if my memory serves. It also doesn't automatically give you a right to work. So just because I'm married to a South African doesn't automatically give me the right to be in the country, number one, or to work. You must apply for work endorsement. And again, it depends on whether or not they will provide the right to work. So please just check that. Then, of course, we have the work permits environment, and typically we're looking at 3 categories of work permit. We've got what is known as a general work permit. The general work permit, as the name suggests, is very open, and it is made by application of the individual, often with the support of the company who is seeking to hire an individual who is not South African. We then have critical skills work permits, and those are governed in line with the critical skills list, which is updated usually on a every 2-year basis. And those are for specified categories of employment or jobs, which come with very specific criteria. So criteria linked to qualification, experience, professional accreditation or membership, etc. And where there are very specific links to the job. So you cannot just move around with the critical skills list. In the past, a critical skills visa holder was a little more free for the duration, usually 5 years, the critical skills list to move between employers. That is not a guarantee any longer. Each time that they wish to move, they would have to reapply essentially to the Department of Home Affairs to have their critical skills visa re-endorsed under the auspices of the new employer. So just be conscious of that. And then, of course, intra-company transfers, again, as the name suggests, is largely used for multinationals where they may be bringing an individual in from outside one of the other operations into South Africa for a period of time, and that is managed, of course, as an external to South Africa application, usually in the embassy in the country from which the individual is coming from, their origin country, and is managed entirely by the company. We then have 2 categories of exemption permits, and we're going to speak specifically about Zimbabwean exemption permits, but we also have a similar setup which was issued later called the Lesotho exemption permit, the LEP, and they follow a very similar method or criteria, and we'll talk to those. And then, of course, we have the undocumented, which are probably the majority of foreign nationals sitting in South Africa, and I dare to say even in your workforces, individuals whose permits have expired, those who have what we would refer to as irregular documentation, and we'll unpack that also. And then, of course, those who are here illegally and do not, in fact, have the right to be in the country, never mind to be employed. So we'll talk to all of those. What we've also just given you is a quick check so that you can have a look in terms of employment criteria and any validity. So as I've said, South Africans, permanent residents and refugees have no restriction. Asylum seekers is per visa condition, and it must be endorsed on the permit, but we are increasingly seeing them endorsed as a matter of sort of normal. ZEP, free to work with no restriction, and based on our most recent extension, they have now until the 28th of May 2027. So another 18 months grace, which has been published as part of the directive. The LEPs have followed a similar point. I was not able for today's session, but I will clarify it with Marissa, whether they are also going to see a similar extension. They were not subject to the same kind of legal challenges, so I'm not sure whether the Department of Employment and the Department of Home Affairs is going to give any kind of extension there. Foreign nationals on relative visas may not work at all. Those who are on an 11.6 visa, which is usually a spouse or life partner, it can only be if they have a work endorsement, and of course it would be for the duration of the visa. Those who are on work permits, it's specified that employer in that role, and so any deviation from that would also deem them to be invalid. And then there are study permits. So there are many foreign nationals who come to South Africa on a study permit, and they may work, but there are very, very clear restrictions here. So work endorsement still has to be given. It's not automatic. And typically it's limited to a maximum of 20 hours a week. So it excludes holiday work. So they can't be saying, well, I'm studying part-time and at night and I'm working during the day. So maximum of 20 hours, and the only exception might be where it is a role that requires them to do practical work. So at DUT, for example. I see a hand. Trevor, do you want to ask a question? Was there a question from Trevor, Lisa?
Can you hear me?
Yes, I can hear you now. Go ahead.
Hi, Natalie. Thanks so much for this. Just my question, quickly. Maybe you're going to get to it still, but just on the work permit, I know you've discussed in the previous slide around the general work permit versus the critical skills. So, on a general work permit, is there still a restriction to certain employer in a certain role, or is that is more open, so they are able to move between employers? Is there restrictions on that specifically as well?
Yes.
So does that state that on the permit?
Yes. So the general work permit will usually be issued to an individual at a particular point in time for a specific role at a specific employer.
Okay. Have you got examples of, so the reason I'm asking is just obviously, again, we come across guys wanting employment. They've got what appears to be, again, for me as a more of a layman in that, I'm not an expert. It's in their passport. It looks like a valid document. It's got valid dates, etc. But is that now valid? How do we assess the validity of that?
Yes.
I have emailed Home Affairs and all of that sort of stuff that they're not always forthcoming in terms of getting back to you, So
no
the
problem.
thing is that I just need to know what that looks like. Yeah.
No problem, Trevor. So we're going to talk about how do you check and what do you check and how do you do that. So we'll definitely get to that. Cool. So there have been changes. So even as I said, with the critical skills visa, in the past, it was can I say more fluid? It was for a period of time and you could move around. But I think given where we are now, the department is becoming a lot stricter. So what can happen, like with the critical skills visa, is I can notify the department and say, I'm Natalie and I'm here on an IT visa. I would like to change employers. I'm going to be doing the same work, and can I do that? And the department would then consider that and reissue. But just an open-ended visa is not going to be the case going forward, because I think there's just too much room for fraud and manipulation, which unfortunately is what we've seen and have seen.
Cool. Thanks.
Great. Melanie, did you have a question? I saw your hand pop up and recognize the name. Hi.
Okay, thank you very much. Yeah, just to add to what Trevor was saying, we see a lot of people with general work permits, and they're not affiliated to a specific company. They just come in and they have a general work permit, which I understand obviously now it's very difficult to check, and doesn't really make sense that they would allow somebody in just for general work. So as you were saying, these are sort of candidates that we should really be staying away from?
I think so.
Yeah,
I think so.
You have been.
So I'll give you some ideas on how to verify, but I would be nervous of that, because I think there's a very strong there's a strong likelihood that it is fraudulent or fraudulently obtained. And that, of course, is going to place you under huge risk.
Absolutely, yeah.
Yeah.
No, thank you very much.
Okay. No problem. We'll jump to that. Okay. So
Natalie,
yes, hi.
sorry, I see that there's in the text box. Is there
Yes,
also
sure.
in the chat box a couple of questions? There's one from Joseph.
Okay.
You can maybe, as we go on, then it's relevant to where we are in the webinar.
Sure, no problem. Will you just read it out to me, Lisa? So, because I
Okay,
won't be able to
Joseph
see it.
says, I have an employee who has a ZEP work permit that expired in December 2021. He
Yes.
reapplied in Feb 23, but has had zero joy in getting his application processed. Would he
Yes.
fall under the ZEP category that
Absolutely.
has been extended until May 27?
Absolutely. Absolutely. So he's good till May 2027.
Okay, Joseph, I hope that helps.
Great. Okay, let's move forward. So if we just have a look at kind of where we are in terms of the Home Affairs, Minister Leon Schreiber, of course, came in as part of the Government of National Unity, 18 months ago now nearly. He's been very focused on driving the digital transformation initiative, and we've seen many of those sort of improvements coming through in terms of our ability to apply online. So overseas visitors, for example, coming for travel can now apply online, much simpler process. They're looking at systems from a perspective of not just improved efficiencies, but obviously to try and close gaps around corruption. We also have the Immigration Advisory Board, which is established under the Immigration Act, and we have business representatives on that board. Business is primarily represented by Marissa Jacobs, who's the CEO of Expat Web. She's an exceptionally competent woman, and she does a great job there. We, as Global Business Solutions, have also developed a very close working relationship with Expat Web. They're an immigration specialist consultancy. So again, we are not. So we help on the labor side, of course, and can give basic guidance. But when it comes to technical assistance around applications, or motivations, we're happy to refer you and do an introduction to Marissa and her incredible team. The most important thing they've been focusing on in this first term of their office has been on the issue of ZEP and LEPs, because we know that it is a critical issue. It has been under various legal challenges over time, and we've just seen now the extension by Gazette, by the Minister, of the extension of the ZEPs to the 28th of May 2027. The intention, my understanding, is for further consultation and to try and seek a more permanent solution, but we'll talk about that now. If we have a look at some of the improvements in the 24-25 period, as per the annual report issued by the Department of Home Affairs, we've seen a drastic improvement in the processing times. Now, some of us may recall that the processing backlogs, they were there before, but became very pronounced over the COVID period. COVID was used as part of the justification for the delays, not being able to have people processed in person, limitations on the resources within Department of Home Affairs. But let's be honest, the biggest problem we have is that it is still largely a manual process, very much like my pet peeve, the UIF, where you're expecting, papers to be physically touched by individuals, and where, processes just take endless amounts of time. But you can see that there've been incredible improvements in many of these areas. Now, Marissa will tell me that I should also inform you of the caveat to say that, for example, in general work visas, a 98% processed on time doesn't necessarily mean that they have been approved. So in many cases, we're seeing a lot of these visas being turned down pretty quickly in the process. So they turned down quite fast. So of course, that doesn't mean it was processed on time, doesn't necessarily mean that the individual has been successful in achieving the outcome that they desired. So there are quite a lot of appeals going on, which of course continues to keep the system full. They are, of course, on the drive to smart IDs as well. And there has been good work done around the corruption issue, because one of the biggest problems we have as a country, and specifically in regards to us as employers, trying to be diligent and to do our checks, is that unfortunately the amount of fraudulently obtained documentation, those that have been acquired through corruption, through bribery and other means, is huge. And it means that it's almost impossible for an employer to not realize that that is false. So there's been a very big internal move by the minister and his multidisciplinary teams to work together with other law enforcement units, and they have been on a massive internal disciplinary process with many people dismissed or disciplined, and where there have been criminal prosecutions and sentencing for internal employees who had been found to have been selling identities and all kinds of other stuff. I saw this
Natalie?
first. Yes.
Sorry, on that, we have a question in the chat box, and I
Sure.
see that Melanie's hand is still up. I don't know if Melanie's got a question.
Okay, thanks.
Or Melanie. Melanie, your hand is
Melanie,
up.
yeah.
Do you have a question?
Sorry, guys, my bad.
Old
No.
hand.
Okay, so we've got a question from Marie. We have two employees from Lesotho, I think Lesotho
Yes.
work, and their work visa has expired. They both applied on the same time. The one has received his new work visa, but the other one still not. What do you do regarding this?
Did they apply in time is the question I would ask. So if they applied in time and they're still waiting for a response, they will be covered by the concession, the backlog concession, which is currently just been extended from the 1st of October to the 31st of March next year. So what it means is if somebody had a valid permit, okay, so they had a right to work, they were valid and all up to date, they went to apply conscientiously for an extension or a new permit, and because the department is delayed, they have issued out, the minister's issued out a concession, which essentially says if they have proof of application, they were documented and legal before, they can continue on the auspices of their own, their old visa until they hear back from the department. So either they're going to hear back and say sorry, in which case obviously they then have to exit, or they've got new visa issued, which may have the same or different conditions, which they obviously would comply with. But they can continue to be employed until the end of what is now March. But you need to monitor them and make sure that they are giving you regular feedback on, are they following up? What have they heard, et cetera, so that you're managing the process your side. But they can remain. Obviously, the one that's got her visa, she's fine. So long as her visa allows her to work, you would continue to employ, I say her, it might not be a her, continue to employ them on those conditions.
And thank you for that, Natalie. We also have a question from Heidi Kotze.
Sure. Hi, Heidi.
Heidi, you can unmute yourself.
Okay, yes, thank you. Good morning. I've got a staff member that was born in Zimbabwe. His mother is Zimbabwean. His father is South African. At a young age, they moved to South Africa, and he's been staying here forever. His third last digit on his ID book is a 0, so it's not 1. When he applied to get, he's got a green ID book, he applied for the ID card, and they said he's not allowed to get an ID card because he's born in Zimbabwe. Is that correct?
Sure.
Yes. He spent the whole day at Home Affairs, and they turned him away.
Right.
I've had heard that they changed that now, that they will give permanent residents and others ID card. So I don't know, again, it's one of those it's like, again, I can't speak specifically of Department of Home Affairs, but I assume it's much like you are. There's a directive that happens at the top, but what some little person in one labor center understands and tells people could be something vastly different from what is happening. That is a bit strange. I mean, if he was... So remember, your country of birth and your citizen status are not always the same. I mean, that can be complicated, So I could be born in Australia to two South African parents. It doesn't make me an Australian citizen.
Yes.
So it depends on the nature of the country. Some countries will say, so long as you're born there, regardless of who your parents are, you would then become a citizen of that country. But that's not the case in South Africa. So,
but his ID book, that third last digits is currently a 0. I would have understood.
Yes, I know.
It was
So
a
that's
1.
why it's strange that they wouldn't give him an ID. That's very odd.
Yeah.
That might just require a little bit of investigation, maybe.
Okay. Thank you.
Okay. No problem.
Natalie, we have another question from Charmaine
Sure.
Lightfoot. She says, I have an employee on asylum that has been renewing it for 15 years. Is there a limit on renewals? He claims he does not want a visa as he will be controlled by government.
Oh my God. Okay. I can't comment to the political issue. If he continues to receive legal documentation, my caution would be to the employers just to verify that beyond what the individual tells you. But I mean, that's strange that government would still just allow them forever and ever to be on an asylum. I'm not aware of there being a maximum limit. I mean, I can check that. But it does seem odd. I mean, how you can still just be claiming asylum for 15 years without transitioning either home or to something else.
Well, we also have Brendan from Bakisa's hand up. Brendan, you can shoot.
Hi, Brendan.
Brendan, just unmute yourself, please.
Yeah, maybe we'll come back.
Okay, then Monica Creer also has a hand up. Monica, you can go. Okay, it seems Monica decided not to have a question. We have a question here from Marcus. In a situation where a foreign national employee with a valid visa goes to their home country seeking medical attention as a result of the Operation Dadla issues that were prevalent in South Africa, would they be supported by the law in the event they never disclosed to the company their whereabouts for months and subsequently dismissed for absconding?
No,
Sure,
so
that's
it's
tricky.
okay. So firstly, I'm not a lawyer, but secondly, if I'm just understanding from what's been given, you would treat them no differently. So an employee is an employee regardless of their nationality. So of course we've got right to work and compliance issues, but even an illegally or undocumented foreign national is still covered by labor legislation. So you have to follow the correct labor law procedure. So if that person essentially left and absconded, you would follow the same absconsion process that you would have with any other employee, and you would be within your rights to have dismissed them if they, you went through the process. The fact that they left, I mean, again, if the person had been incapacitated due to medical issues, you would have followed an incapacity proceeding. But if the person has just left and not told you where they are, when they're coming back, or didn't respond, etc., unless there were extremely extenuating circumstances, I think you've followed the correct process. I don't think there should be any issue in that regard.
Okay, thank you, Natalie. We also have a question from Goodman. We have employees from Zimbabwe and Malawi, and some of them never had work permits from since before my time in the company. If they applied recently and they got receipts, are they allowed to use those to work?
No. So remember, the concession is only for those who had a right to work. So essentially, they've never had a right to work. And I would be very, very cautious if I were you, because if they've now gone and applied and their whereabouts are known and they say that they are working for you, you may well find yourself having an inspection. And if you have employed these people with no documentation, that is in contravention of the Immigration Act. So I would be very cautious. Very cautious. They are not covered by any concession because they were not legal in the first place. Okay. All right.
Then we've got a question from Karen Oliver. Hi, earlier it was mentioned that having an ID makes one eligible to work. Is this sufficient for all cases? For example, if someone is a permanent resident?
Yes. So again, I'm going to put the caveat that you should still, and I will tell you should do this for every potential employee, verify the ID. So just because you see it doesn't mean it's real. And I'll share a real example. So during COVID, and it just so happened that it was a colleague of mine, Marianne, who was helping one of her clients. And I had, because I was supporting, general business as part of my responsibilities with BUSA around COVID-19 tours, I had a support group. And the short version of the long story is that people were finding people disappearing. Some of you might have realized when you put your claims on to the system, and some employees would just disappear, like they just wouldn't capture. Anyway, why that was there was it was a security mechanism which said that an ID could only be captured once in any given claims period, so that it stopped people claiming from multiple employers, for example, because there were those minimums, etc., in place. Now, in some cases, the issue was like a finger error. Somebody had mixed two numbers up, or the payroll had typed in the ID number wrong or whatever, and we were able to fix it. But in this particular incident, what happened was her client, it happened on 1 month, and then to this other client, it happened another month. Anyway, long story short, it was the same ID number. So we said, okay, well, there's a problem, because they said, well, both of us have this employee and they've got an ID book and that's his ID number. Anyway, we got copies of these documents. There were 2 ID books, green ID books. Hold in your hand, not a photocopy, not a scan. Hold in your hand ID books. Same ID number, different names, different pictures. One working in the Eastern Cape, one working in the West Rand. Now, I don't know which of those 2 people is real and which is fraud, or whether that ID number, in fact, belongs to a completely other person and that both of those were fraudulent. But green ID books produced presumably at the Home Affairs or by someone who has access to the documentation. So you have to verify. You cannot just assume that documents given to you are real, unfortunately. We just cannot do that in this day and age. But if a person has an ID, so permanent resident, refugee, South African citizen, and we are satisfied that it is in fact a real ID by doing biometric check, or through LexisNexis or one of those, a verification as part of our pre-employment, we do not have to worry about a work permit. So wherever they were born, it doesn't matter. Wherever they came from, if they have those, then you can employ them freely. Okay. Lisa, I'm going to move forward. I'm just conscious of time. Can we pick up some questions as we continue?
Yes, we do have some questions, and there is a hand that's also
okay. All right, let's do the hand. And then
Monica Kriya. Monica, you can unmute yourself. Maybe it's an accident. Let's quickly run through this question from Shirley. To confirm, if we have a ZEP receipt from 2024, is it still valid according to the extension?
I don't
until May
understand the Z. I don't
2027.
understand the ZEP receipt from 2024. So there is no such thing. So the ZEP was a once off. It's in the passport. It ran from 2017. It expired on the 31st of December 2021. There are no further ZEPs. So that is the ZEP. There were extensions given. So there was initially a year's grace to the end of 2022. Then there was an extension to now in November 2025. They've now extended it to May 2027. But the visa, the permit, still is the same permit that expired in 21. If you have any ZEP that indicates any other expiry date, it is fraudulent. I've seen them with my own eyes. I saw them about 3 or 4 weeks ago. I had a client who said, we're doing due diligence. Can I send you the documents? I'm a bit concerned about these 2 ZEPs because they have the same number on them. That was her concern. But as soon as she sent it to me, they look pretty real. But they were issued, theoretically issued in 2022, expiring in 2025. No such thing.
Okay,
So
Natalie.
yeah.
Then we have one from Brendan Kambule. Given the ZEP and LEP holders currently have valid exemption permits, and that Circular 7 of 2024 states that the permit holder is to be entitled to work in the Republic, but does not explicitly exempt them from labour market tests or other employment compliant requirements. So the question is, can the company lawfully continue to terminate such employees on the basis of operational incapacity without breaching the LRA or exposing itself to unfair dismissal claims?
That is a great question. So if you have contracted that person and they are on an open-ended permanent contract, you couldn't use operational incapacity relative to the expiry of their visa if their visa hasn't expired, because it hasn't. In this instance, it hasn't, because although the original expiry happened, those visas remain valid now until the 28th of May 2027. So if you were going to exit them, you would have to exit them for another reason. I will check that. I don't know if there is a technical argument that could be had, but I think you could find yourself at risk because theoretically they are eligible still to work. So you saying that we are terminating them because we cannot employ you any longer because you do not have a visa or you do not have the right to work is not true. They do have the right to work now until the 28th of May 2027.
Okay, then we also have an interesting one from Karen Oliver. You mentioned that someone on a relative's visa cannot work. However, the second condition of a relative's work visa mentions secondary activity to work. Does this mean that individuals on a relative's visa are not allowed to work at all?
They don't usually, but if there is a specific endorsement to work on the visa, there may be special circumstances that were given. But generally, a relative's visa isn't one. So remember, you've got a 11.6b, which is maybe what she's talking to, where it's not a relative necessarily.
Yes.
So normally relatives would be like my mother, my mother-in-law, my child, etc. If and again, it's unlikely, but there may be situations where someone has applied and requested endorsement to work, but it would have to be specified on the visa itself, in the visa.
Okay, here's an interesting one. If a company spent money on training for a valid ZEP holder, can it be claimed for BBBE?
Good question. I don't know. I'd have to check that. So
Well, they're not making part of employment equity, as you mentioned before, because foreign nationals is outside of employment equity.
So they're not a designated employee. So I don't think you could, because they don't
My
count
assumption
as
would
an
be no.
African male or an African female. They're a non-designated employee, just like a white male is.
Yes, yes.
And I would
So the
imagine the
assumption would
same
be
is
no.
true of BE as employment equity. I need to check
Yes.
that with Richard Riding, our BE specialist, but my
Well,
gut
maybe
feel
if you
is
can-
no.
Yeah, maybe if we can just answer that in the next webinar
Sure.
in November.
Sure.
And then the stupid question, there's not such thing as a
No
stupid
stupid
question. Myrna, do Mozambicans also apply for exemption as the Zimbabweans?
No. No.
And why not? Maybe if you can just clarify why not.
So I'm going to go to Zimbabwean exemption now. So let's get there, okay? And then I'll explain
Okay.
about Zimbabweans and how we got there. All right. So I'm going to go pretty
we've got one or two more questions. Can we quickly finish them, because I think they are quite important. Is there any company that can help expedite the application process for a work permit that's about to expire for a Nigerian foreigner? So we do have a lot of members that do employ foreign nationals, and they struggle with this work permits. So I think if you can maybe direct them to who can assist them to expedite these applications.
Absolutely. I'll share with you, Lisa. I'll just get the name of from Marissa, who would be the appropriate contact in her office. Remember, expediting, we need to be careful with that word. So I think that they could probably assist to follow up. And I know that, in the same way that a company like ours has developed, like I did with UIF, over time, I've developed relationships in the UIF where I can, phone someone on a cell phone and say, can you please check your mail? I can't tell them what to do, and I can't coerce them into doing anything, because that would be untoward. But I can try and ask them to go through the 50,000 mails and read mine. And hopefully they do. And I would imagine similarly, expat will have that kind of relationship. But any company that says that you can pay them to make it go faster, I would be concerned with, or I can guarantee to get you a work permit. Nobody can guarantee that. And Marissa and her team will tell you that. So just be conscious that if you're going to utilize somebody, that you're using the right kinds of people. I think sometimes even these employees, they've gone and said in their minds, and whether they know they're doing the wrong thing or not is a question mark, but they've gone somewhere where someone says, I can get your permit, I'll help you with the process, and I pay the person, and they've gone and acquired this document fraudulently. That is happening a lot. So we just need to be very cautious about expediting. But I'm sure that the expat people could give some guidance, if nothing else, on kind of why it's taking so long, or if there are issues, so that the process, you can manage it effectively on your side.
Okay, thanks, Natalie. We've cleared the questions.
Okay, awesome. So I'm going to go quite quickly through this. You can read it. Obviously, you're all smart people. But essentially what we're saying is, when it comes to the backlog, so this was one of the questions that was asked, because there have been persistent backlogs and there remain backlogs, we have these immigration directives. Now, they're usually for a period of 3 or 6 months. The most recent one was published literally last week. It came or the week before, it came into effect on the 1st of October, and it granted a 6-month concession. So what the concession says is that if there are individuals who have applied, and that's really important. So I can't go and run and apply now and say, oh, I'm covered. I must have made a timeous application. So I must have been legally in the country. I must have, so I can't come afterwards and say I'm covered by the concession. So I was an upstanding foreign national. I came into the country legally. I was here on a work permit. I saw my work permit was coming up to expiry. I went as I'm required and I applied. And I'm now waiting on the government. So I've done everything on my side correctly. I'm waiting on the government and they haven't come back. Those individuals are covered by this concession. And so you would then continue to operate on the auspices of whatever my previous visa was. So if my previous visa allowed me to work as an IT technician, I can continue to work as an IT technician until I am informed that my visa was unsuccessful. As soon as that happens, even if I choose to appeal, I cannot continue to work because I've now been told I don't have right to work. Okay. I can appeal, and I may be able to stay in the country while I appeal, but I'm not going to be allowed to work while I appeal. If I get told, here's your new visa, then that's great. Then my new visa is there, and whatever the conditions of my new visa then become my reality. So ZEPs absolutely are covered, and those who have made other applications who were previously legal in the country, not necessarily ZEP holders, they could be anybody else, they are also covered. You need a receipt from VFS, and again, just remember that in South Africa, nobody can apply directly to the Department of Home Affairs. It's through VFS, which is the sort of the entity which is responsible for doing all the administration around the applications. Okay. Right, we've spoken a bit about digital transformation. I'm not going to talk too much about the Trusted Employer Scheme. It is here, and there is more information available. But what the department has implemented, and this was implemented to the last year and has been extended a second round, is a Trusted Employer Scheme called TES, not to be confused with Temporary Employment Services. And that is an option for companies who want to join the Trusted Employer Scheme. Makes good sense for companies who are either multinationals or companies who rely on fairly large or regular foreign nationals within their systems. And what it does is it helps to streamline the process. So they essentially do an assessment of the company to ensure compliance and governance. They also look at, is it a company that's helping to grow the economy? You know, so they look at the good, the greater good aspects as well. So they do have some financial contribution aspects. And then what it does is it allows the process to happen quicker. So it exempts or waives certain conditions. So under the general work visa, it waives the requirement to get the labor certificate from the Department of Employment and Labor, which is very often the biggest block, because Dell will go, oh no, I know you say this person must be able to speak German, but we don't think it's necessary. You could find somebody locally and have an interpreter. And then they say, no, we're not going to give you the certificate. It also precludes you from having to do the evaluation of foreign qualifications by SAQA. On the critical skills side, it also eliminates the SAQA stuff and certification with a professional body, because we also know that that can be complicated. And then on intra-company transfer work visas, it does away with the need to have a skills transfer plan. Because what they're saying is, we understand if you're bringing someone from your, New York office to your Cape Town office for a period of time, it's not necessary to do that. Now, there are selection criteria. There's some pledges. You've got to be at least 60% of your staff must be South African. There are various points, a system which they look at in terms of investment in the country, skills transfer, equity, etc. So again, if you want to see more detail, there's a lot of detail available for those that are interested, but just really wanted in this first session to highlight that it is available. So good option certainly for larger employers. I would suggest probably more likely larger employers who have a high volume of visa applications going through the system. Just in terms of increased immigration enforcement, we have seen a marked increase in deportations. In fact, just under 50,000 people were deported in this last financial year. It's the highest in 5 years, and in fact exceeds, more than doubles the number of deportations that have happened in France and Germany, or if we look at it, we've done more than them combined. A lot of blitzes taking place, very often in construction, accommodation, hospitality, mining sectors where there is a high concentration of foreign nationals. Okay. Right. So let's now have a look at the ZEP specifically. All right. So what is important to understand is what the ZEP is. So the ZEP is in fact the third iteration of a special dispensation. So in the mid-2000s, when everything was literally falling apart in Zimbabwe, and there was a lot of political tension between ZANU-PF and the other party. There were a lot of people coming across our border claiming asylum. And they were claiming asylum not because you can't claim asylum for economic reasons, okay? So that's excluded. I can't say, well, I can't find a job, so I'm coming here. It's about political persecution, etc., poverty, etc. Bridge in particular was overrun, and the Department of Home Affairs actually couldn't cope with the volume of people that were coming through. They just couldn't process them. And so what they did was they created the Dispensation of Zimbabweans Project, the DZP, and it created almost a fast track to get people through the process and into the country. And the idea was that they looked at them very simply to say, did they have documents? And many of them did have a document. They didn't have a criminal record or anything like that, and they allowed them to come in. They said, right, you can come in. Now, of course, they didn't want to be responsible either for now having to feed and clothe and look after everybody. So they said, you can come in and you can operate freely while you're here. So the original dispensation was intended just to be for 18 months to 2 years. I think the idea was that when things settled down in Zimbabwe, the people would go back. It then was formalized into what was known as the ZSP, the Zimbabwean Dispensation Permit. And they requested people to come forward, and that was in 2009, to come forward and formally register themselves, apply and say, I'm here, I'm a Zimbabwean, this is where I live, this is what I can do, etc. And they were issued with ZSPs, and those were valid for a period of 5 years. The ZSP then expired, and it was part of its criteria was that it was non-renewable. So it was for the 5-year period, free to live and work. It specifically excluded the right to claim permanent residence. So normally when you've been in the country for 5 years legally, you can then apply if you want to be considered to be a permanent resident. It specifically excluded that provision. At the end of the 5 years, there still was an upset and carrying on in Zimbabwe to a degree, but also the reality that many of those individuals had been settled in South Africa longer than the 5 years, because many of them had come in the mid-2000s. And so what they did, they couldn't extend the ZDP, so they just, ZSP, they created a new one, the Zimbabwean Exemption Permit. And the Zimbabwean Exemption Permit essentially was a mirror copy of the previous one. It was issued in 2017, and it was valid for 5 years. Okay. And again, it said you could stay in South Africa, you could live and work freely, you could travel as many times as you wanted across the border, and but you could not claim permanent residence using any of the time spent in South Africa. There were 178,000 ZDPs issued. Okay, remember what I said? The stats say there are over 1 million Zimbabweans in South Africa. This is a very small proportion. So please do not conflate Zimbabwean equals Zimbabwean exemption. It does not. There were 178,000 ZDPs issued. Those 178,000 people, and they don't think all of them are still in South Africa, only those people are covered by this dispensation and extension. So it expired on the 31st of December 2021. And the then Department of Home Affairs Minister just announced, sorry, we're not going to give you another one. So remember, there was no renewal allowed, but what they'd seen, and think about contracts in the temp space, rolling contracts, we create this expectation. So we had the DZB, then we had the ZSP, then we had the ZEP. And so there was an expectation from these Zimbabweans, many of whom are gainfully employed or own businesses, have own homes, cars, live in South Africa. Many of them have had children who've never, ever lived anywhere except in South Africa. They don't even speak any of the Zimbabwean languages. They are entrenched here. Their lives are entrenched here. And so when this notice came out and just said, well, sorry, it's done now. Everything's fine in Zimbabwe. You can just go back. And they said, if you don't want to go back, then you must regularize your stay. So you can apply for another permit. So you could apply for a general work permit, a critical skills visa. If you're married to a South African, you apply for a spousal, 11.6 visa. If you are a business owner, you could apply for a business visa, etc. That's what you must do. Regularize yourself, because there is no longer going to be a thing called a ZEP. Because there was pressure, they then said, okay, we'll give you a year grace. So that first was a year's grace until the 31st of December 2022, because the reality is I can't just pack up my stuff and leave in 5 minutes. Process of application would also take time. So that first process was an extension to say you have a year's grace, not extension, but grace. And in that time, you are expected to figure out either are you going to pack up your trolley and go back, or are you going to apply for something else and stay? Now, the reality is that many of these ZEPs are individuals who wouldn't otherwise qualify for another visa. So I'm working as a supervisor in a warehouse. I am very effective. I've been at that company for 10 years. I'm a great employee. The company really wants me. But when you look at a general work permit, the argument will be, well, any South African can do that job. There's no critical skill linked to it. I can't justify why it has to be you and not someone else. And so it becomes really difficult from the general work permit perspective. Many of these are individuals who don't have critical skills, especially because our critical skills list has escalated the level of qualifications in many instances to honors and even master's degree level. It's very difficult for them to get that. I read one of the case studies was of a guy who'd been in South Africa, I think 12 years. He owned an IT business and employed 35 people, the majority of whom were South Africans. In order to get his business visa, he was going to have to pay, I think it's 5 million rand kind of investment. He didn't have that money. So what's he going to do? He's going to pack up his trolley and leave and retrench 30 South Africans. I mean, it makes no sense. Anyway, as a result, there were a variety of legal challenges which were launched. The most public of them was the Helen Suzman Foundation. And they challenged it on a technicality because they said there had been no consultation. And they won on that technicality. There is, of course, there were also other groups. The name escapes me. I think they're called the Zimbabwean Special Interest Group or something, which was a collective of people affected, these ZEP holders who had engaged legal representation as a collective, who also put forward the argument to say that, there should be consideration for them because it wasn't their fault that they didn't have the opportunity at the original time. Had they come in and been processed as asylum seekers, many of them would have been granted refugee status. And then they would have been able just to be here and this wouldn't be an issue. So they were arguing it's not their fault that at the time government couldn't deal with them. So they should be reconsidered either under those conditions, original conditions, or they should reassess the ability for these individuals to be considered from a permanent residence point of view. So although the original permits did say specifically that time spent here under those permits couldn't be counted for permanent residence, they have challenged and put that forward to say, again, it's not fair, it's not their fault, and that they should have an individualized opportunity. So if I'm an upstanding, contributing member of society, should I not be allowed to remain in South Africa and pay my tax and do my thing as I've always done? So that's where we find ourselves. So we've had this, and it's a political hot potato because of, if you remember, as we started the session talking about foreign national anti-foreigner sentiment, we have some very strong anti-foreigner sentiment in certain quarters within government even. It's been a hot potato. So we had the can kicked down the road to 28th of November 2025. It's still been bubbling. It's still not resolved. And so we've got a new minister now. We've kicked the can down the road very conveniently to 28th of May 2027, which is what? After the next elections. So we don't have to deal with it now. We'll deal with it then. And that's essentially what's happened. I suspect that going forward, there is a likelihood that we may see and some kind of option for those individuals to either be considered on a very unique visa with a long-term, another version with a long-term horizon, or possibly for them to be considered for permanent residency status, because these are individuals who came here legally. They have maintained their legal status all the time, and they shouldn't be treated the same way as somebody who's just, swum across the river and come here without papers and etc., etc. So what does it mean? Okay, until the 28th of May 2027, even though their visa in their permit in their ID is expired, remember the date's expired, they cannot be arrested or deported. They can come and go into South Africa with no problem. They don't need to get another visa. So if they're going to apply, they can, of course, apply for something else. And in fact, I would encourage those that have the possibility of securing alternate right to remain, that they should be exploring that. But they can continue to work as they always have, so long as they are not obviously considered undesirable. So they will not be considered undesirable by virtue of the fact that if they found to have an expired permit. Okay. So what's going to happen next is that essentially this process or this extension is going to allow for further consultation with key stakeholders. And the intention is that those consultations, because of course, remember, this was the mandate position from the court finding, is they need to find a solution. So some of the things they're thinking about, as I said, is a potential pathway to permanent residence, how they might be able to create a special new visa category, or whether there's some kind of a transition to help people mainstream into existing visa types. So we wait to see where we are. Now, what you need to do, please, is don't assume that just because someone told you they're a ZDP that they are. So you need to make sure from a compliance point of view that you go and identify who is in fact a ZDP, and you need to confirm their ZDP in their passport. Now, it may well be an expired passport, but they should still have it, okay? Or a copy of it. And then we need to be conscious of fraud. I mentioned earlier that I've seen some so-called ZDPs, which were issued in 2022 and 2023 and 2024. No, they were only all issued in 2017, expired at the end of 2021. Full stop. There's no other period or version of it. And then you need to just make sure that you keep in touch with them, that you monitor what is happening, so that you can keep in line, because they may well be applying for other things. And remember that those processes need to be monitored too. Yes, Heidi.
Hi, sorry. Let's just test what you said now. I've got a ZDP in front of me, a copy in their passport. It said issued at head office on 2017.
Yes.
But the expiry date is December 2021, not the September. Is that still right?
No, December 2021 is correct. Yes.
Okay.
So that's an original ZDP. So that even though the document has expired, that document is still valid now under the concession, which is now till the 28th of May 2027.
Okay. Thanks.
Perfect. No problem. Okay, excellent. So let's just move forward now. Or I don't know if you normally want to take a break. No, we're nearly coming up to time. Let's just keep going, and then we'll do our comfort break after that. Right. So we've got variety of legislation, which of course we are governed by. But I've mentioned before, and just so that we're all on the same page, even illegal, inverted comma, foreign nationals are protected by the Constitution and labor legislation. So please just make sure that we deal with them appropriately. Now, I just want to talk about you as an employer. So there are prohibitions in the Immigration Act and the Employment Services Act for employers. It says no person, and remember, person can be a juristic person, i.e. an organization, or an individual person, me and my house. No person shall employ an illegal foreigner. Okay? So if I know that they do not have papers, I may not employ them. Or a foreigner whose status does not authorize employment by such person. So yes, they might have right to be in South Africa. They've been allowed in as an asylum seeker, for example, or a relative, but they are not allowed to work. They do not have endorsement to work. Or a foreigner on terms, conditions, or capacity different from those in their status. Now, this is another area where people make a mistake. So somebody has a critical skills visa. They came in as a specialist IT developer. We now promote them to an IT project manager. You have now broken the rules of the visa. He is not allowed to be an IT project manager. He's not allowed to be an IT development manager. He is a developer. He must remain in his category, because then I am breaking the rules of the visa. And when they come to inspect, they want to see what is the contract, what does the payslip say, what is the person doing, what does the visa say, and they cannot not be aligned. So please be conscious of that when we are hiring. In Section 38(2) of the Act, it goes further to say that employers must make a good faith effort to ascertain that no illegal foreigner is employed. In the Employment Services Act, it says employers may not employ a foreign national without a valid permit, and an employee retains their rights to enforce claims despite an invalid permit. Okay, so firstly, simple terms from what the Immigration Act says: do not employ someone who doesn't have a valid permit. And even if you did, or the permit becomes invalid, please remember that the employee still retains their rights under the Labour Relations Basic Conditions, Constitution, etc., etc. Section 9 says an employer may not require or permit a foreign national to perform work that is not authorised by their permit, or to engage in any work contrary to the permit terms. Again, that's really just reinforcing 38(1)(c) in the Immigration Act. So simpler language in the Employment Services Act, but they speak to the same thing. So what is good faith? What does that mean? So what will the court look like if you are referred by the immigration authorities? So in the Immigration Act, in Section 38(3), it creates what is known in law as a rebuttable presumption. And it says, if employment violation is proven, the employer is presumed to have known. So almost you are guilty, and you must prove that you are innocent. So if we find somebody who is illegal, or we find somebody who is working in contravention or in an expired capacity or in a different capacity, we will assume that you knew what you should have done. And that will then require you to prove in defense in the court that you employed them in good faith, number one, and that you had done all compliance with due diligence requirements. They are especially strict for employers with more than 5 employees, so not a very big business, or if you have had prior immigration issues. They take a much firmer stance. So it requires you to be very, very conscious in our employment efforts. What happens if you are found guilty? So in Section 49(3) of the Immigration Act, it says if you employ an illegal foreigner, so remember, an illegal foreigner is somebody who doesn't have papers or is, in contravention to the criteria of their visa. First conviction is a fine or up to 1 year in prison. First time. Second conviction, imprisonment of up to 2 years or a fine, or third or subsequent imprisonment up to 5 years without the option of a fine. If you are failing in your duties as an employer, and that's Section 38 to 46, all of those things, due diligence, contracting in accordance with terms that are no less favorable than South Africans, labor law rights, etc., you can have a fine or imprisonment up to 5 years. The Employment Services Act creates additional liabilities which are aligned to those of the Immigration Act, but you have dual liability under both acts. So very important to recognize that this is a serious issue and is taken very seriously by the department. So if you have a look, there are also extended liability provisions, and this is going to be important for those of you who have subcontractors, contractors, and even TES providers. Okay, so the extended liability provisions say you are prohibited from aiding, abetting, or assisting, or even helping. So they use all of those words. Illegal foreigners or foreigners violating their status by including issuing licenses or authorization for business, entering agreements for business or profession, conducting business in cooperation, assisting in conducting business or obtaining licenses on their behalf. They make an exception for necessary humanitarian assistance. So if somebody was dying and you help them access medical care or something like that, but it would be an extreme exception. So what this means is that even though I might not be employing the person, if I provide information that is going to help them get access to a visa in an inappropriate way, if I hire a contractor who is not allowed to be in South Africa, if I, a TS provider, your cleaning service, your security company is putting staff members on your site and they are not legally employed, you also potentially could have liability from that perspective. So who bears the risk? Is it the company? Is it the person? So under the company, of course, the company can be prosecuted and fined. Also reputational damage. And of course, you start putting a spotlight on yourself, which means that you will have a greater degree of scrutiny from Department of Home Affairs, Department of Education, Department of Employment and Labour, Skills Development, all of those good things. And then under personal liability, who could be held accountable? Well, directors, HR managers, hiring managers, potential imprisonment, and criminal records for individuals too. And as I said, we have had clients of ours where production manager, HR manager, operations manager have found themselves frog marched off the premises in handcuffs because they are deemed the most responsible party at that point in time. I saw your hand, Kevin. Go ahead.
Yeah, thanks. Messing around with the mic. Thank you for a great presentation, Natalie. Really, absolutely wonderful. I just wanted to address or maybe just mention in passing, which is an issue concerning the tripartite relationship that we have as TES, as a service provider of labour, of skills, whatever you want to name it, which is from a legal point of view and a legal liability point of view has a very broad band with reference to statutory requirements and rights. I think this is one of the things that is a nub of hopefully what will come out from your presentation. Well, look, it's already there. I think it's pretty much a safe for what it is situation. Is where we find ourselves as that third party, and once again it's generally where you have drivers coming across the border, being employed by larger organizations, and you're the middleman, you're the test, you're the mediator, and you do all that has to be done. But obviously, a lot of what has to be done has to be done on a regular basis in terms of issues around rebuttable provisions, presumptions, and use the test. Don't always have the full authority or the full involvement at that time. I hope I'm making sense. What I'm saying in short is, who then really bears the responsibility at the end of the day to ensure that Mr. X, who's employed as a co-10 driver for Mrs. Y, and it's a representative of Mrs. Y is frog marched, as you just said, off the site, handcuffed, and then one starts looking at the investigation, and they come and knock on the door of TS XYZ. Does that carry through to the initial employment process? Does the TESD then are they obliged, or do they bear the same responsibility to ensure that the person that is placed with the client has the legal credentials? Is there a cooperation or a responsibility? Yeah, that's really, hopefully, that's really what it's about.
So, Kevin, I mean, it's a great question. What I would like to suggest is that for part 2, I will make sure that we've got that kind of triangular relationship and the legalities, because I don't want to give the wrong advice. But my immediate thinking in reading as I've seen it is that, and in practical sense, I mean, we had one client where they actually had work being done on the site. It was like maintenance or repairs work with a contracting company that was contracted as a business. And when the raid happened, they obviously asked for everyone on site's documentation, and these guys didn't have, or one was a foreigner without a permit and whatever, and they still took umbrage with the production manager on site, because they're saying, well, these people are working on your site. They weren't even in a triangular relationship. I mean, that was a contracted service to perform work. And yet, of course, they're just saying, well, they're here, they're performing work. You should have made sure that you were dealing with reputable people. I'm sure that in a court of law, or even it probably didn't get that far, you could have argued about that. But TS, I think, is different because it's complicated by the deeming provision after 3 months. And as you say, if I'm transitioning workers that were employed by the clients and now they're on our payroll, and it's quite complicated and quite messy. So I think let's I made a note. Let's tackle that in more detail and with the technical expertise of one of my legal colleagues, so that we can address that in part 2. All right.
Thanks very much. That's great, Sarah.
Thank you.
Thank you very much.
And then, if I'm conscious of time, so I'm going to go quite quickly through the rest. And again, I'm happy to also pick up some of these other concepts as we go into second hour. I thought 2 hours was a long time, but actually it goes by in a blur. So if we just have a look, of course, increased inspections, typical scenarios, which results in potential prosecution. Obviously, if we're employing people who we haven't verified, and that's a risk. We don't keep track of the visa expiry dates. I think we can all agree that time just seems to go faster and faster the older we get. And so, we think we've got time, and all of a sudden 2 years has gone by and we forgot to check, So it's not intentional. We did employ them at the time where everything was valid, and subsequently something's changed. We don't have accurate systems to track. And we obviously continue that employment relationship beyond the expiry. So it's very, very important. We have seen focus, and I've mentioned this on many occasions, but those of you I know specifically in construction, manufacturing, you need to be conscious that there are certain sectors where there is a hyper focus from Department of Home Affairs, Department of Employment and Labour, construction, hospitality, agriculture, retail, manufacturing, mining. I think there is an understanding because of historical migrancy, but still, those are areas where we know that there's high levels of foreign national employment or concentrations of foreign national employment, and so those are the ones that are very much hit. So what I've got here, and again, I'm not going to read through the slides. You're all smart people. You can do it. But I've given you some of the obligations that you need to adhere to. So before we even go to hiring, we need to remember South Africans first. So ideally, we should attempt to fill the position with a South African citizen and or a permanent resident. Now, obviously, in the context of employment equity and sector targets, this becomes even more important because a foreign national, like a white male, is a non-designated individual. And so they are the polar opposite of what the sector targets are attempting to achieve. Typically, we've had to get a Department of Employment and Labour certification before you can get a general work visa. So what had to happen was you had to be able to say to the Department of Employment and Labour, we've tried, here's where we've advertised, we can't find anyone. They then go and look and see if they can find someone, and they will come back and say yes or no. And again, with respect, they don't always understand the nuances of work and what work is required. So they very rarely would ever give a certificate. This slowed down the process significantly. At the moment, there is a general kind of waiver because there's been such a slowdown. So at the moment, general work visas are moving. They're not waiting for the Department of Employment and Labour. But it doesn't mean that automatically the Department of Home Affairs will go, oh, yeah, sure, we'll just allow a domestic worker. Because the argument will be is why do you have to have a Malawian houseman when you could have a local person there are many people who could clean a house. It's not a high level of skill. It's not a requirement. Skills transfer plans, compliance, of course, and then all the others that are necessary. In terms of a due diligence check, please make sure that you actually see the stuff with your own eyes. Take your own copy. So get them to bring the documents because it's much easier to present a falsified or forged document electronically or in a photocopy. Much better to see it in person because you can actually kind of get a sense of its legitimacy. We must also make sure that we check them. Please verify them. So to the point earlier that somebody made, trying to go through Home Affairs or VFS is not the most efficient way. So it is one of those where I strongly recommend that you utilize a third party like a LexisNexis, a Kroll, a iFacts or one of those. Yes, you're going to pay to verify the ID, but I promise you prevention is better than jail. Or fines. So just do those checks, and not only on those that present themselves as foreign nationals. This should become part and parcel of our pre-employment verification for everyone. Unfortunately, we have high volumes of forgeries. So these are fake documents. So it's a physical forgery. And again, I mean, just look at what Canva can do. Look at how easily it is for just everyday souls like us to create pretty fancy looking stuff online. It's very easy to forge stuff. Fraudulent, of course, false information in a document, either, and this is often the case with visas and things where dates or names are changed. And then, of course, fraudulently obtained, arguably the most difficult to pick up in a due diligence because this is somebody who's acquired it through dishonest means, potentially through corruption, etc. So we must be conscious of the fact that the due diligence needs to be robust enough that it would pass that good faith test. What we've given you is sort of a 7 pillars of the due diligence. So it gives you a little compliance framework that you can refer to in terms of the inspection of the documentation itself, verification channels, of course, record keeping, very, very important. You must have these records on hand, whether they've in a file or on a computer, obviously is based on your own systems. But if you have an audit or an inspection or a raid, you need to be able to access this information pretty sharply because it is expected for you to have this information. You must also retain it for at least 2 years post termination of employment. And then, of course, you need some form of monitoring and oversight. Very important to track visa expiry dates and to put in calendar alerts. So 1, it's an alert for yourself. 2, it's an alert for the employee. It also means you can start a fair process, documented process, to comply from a labor relations perspective as well. HR, payroll people, those who are in the kind of the front line, try and invest in some training and awareness for them. They certainly are not going to be, not expected to be immigration experts, but to have an understanding of the different kinds of visas, what they look like, to raise some red flags. Certain numbers don't make sense. If you suddenly got 5 people arrive, so-called unrelated people, and they all happen to have their visas issued at exactly the same Department of Home Affairs center on the same date with consecutive numbers. I mean, that kind of stuff needs to ring bells because that doesn't make sense. That smacks to me of a connection somewhere along the line who's bought the papers. Of course, you need written policies, again, on how you do this. Again, almost certainly will form part and parcel of your employment equity transformation agenda. Please align contracts with permits. So when you're hiring a person who's on a fixed term permit link their contract to that time frame. It just helps make the process simpler. Obviously, it's not only about time frame, it must be linked to the validity and ongoing validity of their permit, because it is possible that something could change. Remember that in some instances their permits might be revoked or something could happen. So it's not necessarily going to happen on the date of expiry, but linked to the conditions of the permit. And then, of course, where necessary, engage third parties, whether that's obviously immigration specialists, so that you can make sure that you've got everything in place. So just a couple of warning signs we've given you. Some are obvious on physical documents, obviously misalignment, altered photographs, missing security features, handwritten corrections without official stamps. I laugh because we still see handwritten stuff, especially on asylum seeker certificates. Just because it's handwritten in South Africa doesn't necessarily mean it's not valid, but just put a question mark. And then, of course, statuses. Just make sure that it makes sense. So where people are claiming to be on a study visa, but they're not actually enrolled anywhere to study, and where they're applying for jobs that don't align with their visa conditions. So we just need to check for those. And then, of course, once they're employed, we need to make sure we have ongoing compliance in terms of monitoring, especially tracking the expiry and renewal process dates. And then, of course, we are also, by the way, if you hire a foreign national, when they exit your employment, you are required by the Immigration Act and its regulations to inform the Department of Home Affairs that they no longer work for you. So you are supposed to notify them to advise them that the person no longer is employed by you. And then, of course, monitoring any changes. So what documents would be typically required in an inspection? They would want a certified copy of the passport, the copy of the relevant visa or permanent residence, for example, proof of employment, and it must match the visa conditions. Are they registered for tax? Have they got a job description, if it's not already in the contract, that aligns with the visa conditions? Ideally, they want to see due diligence. Did you check that this is actually valid? And are you maintaining it? So very important that you have this information for all of your foreign national employees. And then in the final section, and again, I'm just going to run you through it. You can read it. And obviously, if anybody's got questions, they can reach out to me. But we've just given you a little risk assessment process. What is it that you need to look at? So if we look at identification, how many do you have in your employment? Which roles are they occupying? What is the nature of their status or contract? What kind of visa categories? Do we have documents for everyone? Are they working in compliance with their conditions? How soon are they going to expire, or have they expired? Have we done official verification? Do we have records of that? And then typically also we start to look at things like where we've got people in our organization thinking more around operational sustainability, is where are these people working in our business, and how likely is it that they could get a renewal or a new visa? Think about the ZEPs. Okay, we've got another reprieve of 18 months, but that supervisor example I spoke about earlier, how likely are they going to get a general work permit? Probably not. So even though they're going through the process, what is it going to mean if that person leaves? So operationally, what is that impact going to be? Have we got somebody who could be a successor? Do we have gaps in knowledge? Do we have institutional knowledge locked in those people? Can we do the skills gap analysis? How do we manage that kind of transition process? And sensitively so, because many instances, these are really good employees who don't want to go. We don't want them to go either. And so how do we manage that process? And then obviously looking at transition plans potentially and how we move forward. So if we just look at managing non-compliance, okay, if we discover expired visas, we must suspend work activities, okay? We cannot continue to hire them if they have an expired visa and they have not timelessly applied for a renewal. You also need to just be sure that we've got all the documents, because part of what has happened to some of our clients is people will suddenly do this process and go, oh, And again, I'm the new HR person, assumed everybody was employed with documents, and we suddenly discover the files are pretty empty. And now we're trying to get the documents from the employees. Of course, prevention better than prosecution. Be cautious where employees can't produce documents. Long stories about I lost my ID, I lost my passport, and we know these things can happen. But continued reluctance to provide you with documents very often is a clue that they aren't in fact legal, or what they've put forward is not true. We need to just make sure that we manage it. And of course, how you're going to manage it depends on the nature of what happens. If you've got individuals who are unable to work because they don't have a permit, then it's a no work, no pay, potentially for a period of time following an incapacity proceeding. If it is misconduct, of course, so somebody who's knowingly provided you with falsified documents or misrepresented themselves, of course, that's a misconduct offence, and you would follow misconduct in those instances. So if we just look at incapacity, and again, I'm happy in the next session, if you'd like, we can go through this in more technical detail. I've just given you an overview here, as I imagine some of you may already be in this boat and you don't want to wait until November to begin the process. So if we don't have a solution available, we found now that they are expired or invalid. We then need to explore whether there are any alternatives, and typically with somebody who hasn't got right to work, there isn't an alternative because we can't legally employ them. We then have to look at if could we wait. So think about it the same way as if somebody got injured. Okay, if somebody got injured or had a medium-term, long-term illness, this is somebody who's a good employee. You would like them to come back. Can we send them away on a no work, no pay? Could we get in somebody as a temp to cover them for this period? We check in with them in 3 months' time, or in whatever. I mean, there's no finite amount. You decide whether it's 2 months, 3 months, 6 months, and say if by 6 months from now you haven't been able to get another visa, then I'm sorry. Just the same as if somebody had come back and they still were not recovered from the injury or the illness, we would then come to agreement about an exit. Okay, but you must follow the processes correctly. So we've given you a little outline of what you need to communicate ideally prior to the expiry of the work permit, or of course after the expiry of the work permit, which is very often when we find out. And we've given you an example of a layoff letter, which would be compliant with the Labour Relations and the Immigration Act, so it's got references in there as well. Okay, I've also just presented this information slightly differently. I know some of us are visual rather than all the content, so just kind of conducting your due diligence, thinking about what we need to have in place. Each individual is, of course, going to be different potentially, so we may have a different course of action. Very important to think about the organizational risk assessment, because if these are people who can't work anymore because they don't have right, or where there is a likelihood that we will not be able to retain them because they will not get another right to work, we have to think about what the impact is going to be on the business. What are the alternatives? What is the kind of time frame we have available to us in terms of trying to train people up, creating potential leadership vacuums in the process. We also have some possibilities when you start scrounging around, of course. Somebody who is got a bit of pressure put on them because they're now being discovered to not have the right papers potentially could abscond. So they just don't come back. Okay. Follow the standard process. The fact that they are an illegal foreigner is irrelevant. Follow the process from your side so that you keep your nose clean, as they say. Those whose processes or they're coming to an end, of course, now the ZDPs have got another reprieve, but we see that sometimes with individuals who are the permit is expiring imminently. They don't really think they've got a good chance. We might have some issues with engagement or productivity, etc. And then, of course, those that are cooperating in the process, how can we incentivize them? I think specifically of those where we want them to train a backup just in case. I mean, it's a hard thing, that everybody wants to be indispensable, or they think they're protecting themselves by being indispensable. How do we recognize and encourage them to share knowledge, to teach skills, so that we are building capacity and sustainability and continuity in the business? Okay, we've got a couple of compliant exits for you there. Obviously, depending on the nature, If you already have contracts which have an end related to the permit, that's pretty simple. On the disciplinary side, of course, misconduct, and that would depend on the nature of what's happened in your investigation. And then incapacity and, of course, deferred decision for those where you might want to give them some time. And then I've just given you a map as well, just kind of the process and thinking about the opportunities too. As much as it's difficult to have people exit our business, those gaps, of course, provide opportunity, especially within the context of employment equity, to replace in line with our sector targets, where we can also look at perhaps relooking at our structures and then, of course, the transition process. And if you want any help in any of these areas, as I said, we've got a fantastic legal team who can support from the legal side, as well as from the OD side, so the employment equity side, the organizational design side. I'm very happy to help from that side. So I'm conscious I've gone over by 4 minutes. Sorry about that, but hopefully it's been good information. I know we've taken some questions along the way, but are there any others? I'm comfortable. I've got another 15 or 20 minutes. I don't have to rush off straight away, so I'm comfy if there are some more questions that people want to take. But we will also be back on the 12th of November. Lisa, over to you and the questions.
Yes, I'm going to share it now with you. There's a question from Joseph. The employees was issued in July 2018, but it expires in December 2021. That's regarding their work permits.
Is it a ZEP?
Yeah.
No, that should be fine. So if it's a ZEP that ended in 2021, it should still be covered.
Okay, and then who would be imprisoned, the CEO or the MD or HR? I think let's leave that. I don't want you to answer that. We will address that in
We'll
part
do that
2
next time.
because Natalie is going to bring some interesting case studies for us, and we're going to name and shame. Obviously, because it is public knowledge where it is, and you guys can maybe start looking for that on the internet. A couple of big companies that has gone through that with the rates with the Department of Employment and Labour as well as SAPS. So I think we are not going to say that. I think you should just keep a number close if you need to phone the guys from Global Business if there's any imprisonment until the 12th of November when our second part of this webinar would be. I think then the same goes for work that needs to be done by contractors on site. Are they covered if their employees is illegal or not? I think we will address that also in the second part. More practical tips on that. Yeah, the slides will be shared. I can't see any other questions that there is questions, but I would like to keep those for I'm just getting from Krista here from the Q&A. So this comes from Zanisa. I probably had to ask this question earlier. I have a foreigner from Burundi. He has a formal recognition of refugee status in RSA issued on the 11th of August 2023. I do not see an expiration date. Should he reapply on this?
No.
Or is it a valid?
No, so once somebody's been given refugee status, it's pretty much indefinite unless they do something terrible. So refugee is entitled to be employed in the same way that a permanent resident is.
Okay, I think that's good. And then also one of our participants has mentioned that we can SMS the ID number and the permit number to 38021. Thanks, Heidi, for that.
Oh, good. Thank you.
Yeah, so you can SMS to 38021, the ID number and the ID and permit number, I assume. And then employee's visa application has been rejected and he appealed in the 10-day period. He was allowed for appeal. Is he now legally here and may he work or must we release him temporary?
I will double check that, but my understanding is that his previous permit is no longer in play. So he probably should be on a no work, no pay you could say pending the outcome of the appeal. So, you know, again, you can keep in touch with him, and if his appeal is successful, then you could re-engage him. If it's not, then of course it would be an incapacity exit.
And then one thing that we can also address in the second webinar, Natalie, is maybe the UIF contribution for foreign nationals, because I know that 80% of companies that employs foreign nationals doesn't always do the UIF contribution. So we will touch base on that. We've got a hand up from Trevor.
Go ahead, Trevor.
Hi. Again, just thank you for the presentation, and obviously we'll continue to work through the slides. I think for me, my question is just around the due diligence around those fraudulent documents. So if we're going through a due diligence now, people are employed on a general work visa. Can you assume then, like I said, if it doesn't state on that visa, on that general work permit, linked to that specific employer, that it's automatically invalid?
No, I would suggest verifying it. So I would suggest verifying it, and Heidi's just shared that great tool, the SMS number. I would send the ID, whatever their
passport
ID,
number.
or their passport, or their passport number and their permit number, and just see what comes back. If it comes back as valid, I think you would be fair to continue. So if there are no restrictions specified, you can probably employ them as you are now, but at least you've conducted due diligence. But I would hope that process would turn up or flag any that could be dodgy, you know, in that process if you can't verify it.
So up until now, that's what I said. So having looked at some general work permits, like I said, obviously going through the normal stuff, spelling mistakes, permit numbers, looking for that, just sort of that low-hanging fruit, easily identify errors. Like I said, some of it is actually just, it looks very, very legit. Sending that out to organizations that's coming back as it looks valid. But in terms of my understanding, was the only way to actually verify it was through the DHA itself. And if they're not coming back, then I'm also going, well, my due diligence is somehow being hampered. I will look at, obviously, like you said, these extra tools that are there. Only then once it comes out that it's then invalid, the employee obviously could also have very well done that in good faith, and they've been duped on the side by an unscrupulous DHA official or somebody that's posing as that to obviously fleece them of money. In that case, it would be an incapacity issue. Otherwise, if it is that they've actually gone and done fraud, then it would be a misconduct issue. So, which again would be obviously quite difficult to prove. That if they were knowledgeable around that fact, but I think from a paperwork point of view, if everything looks right, you've reached out, you're not getting any sort of red flags that are coming back. I mean, I was feeling a lot more comfortable that I've done some due diligence before this webinar, but knowing the consequences are quite stringent, I think it's just trying to make sure that every box is checked. All right. So well, can whoever mention that number, that 38021, is that only for permanent residents or is that for all foreign nationals? Would we be able to just clarify that?
I'm not sure about it. What we will do, we will, when we share the slides, we will also put a footnote on the email with that information for you.
Perfect. Thank you so much. And then would you also, if needs be, is there any way to just point us in the right direction? Like you said, Natalie, with just your team, if there is any other sort of legal consulting or team that thing that we need just in terms of contact details, would that also just be shared when the slides are distributed? Perfect. Sure. Thank you.
My details are on there, Trevor, so you can also just reach out to anybody, can reach out to me, and I'll help it where I can, refer it where I need to. So either internally to one of my legal colleagues or externally. I know we did a webinar about a year ago with one of my litigation colleagues who has obviously litigated on behalf of clients in this situation, and also included a gentleman who is a criminal attorney and had some previous experience in SAPS. So again, hopefully you're never in that situation, but should it happen, we also could guide you, you know, at pretty short notice to getting some expertise and support if, God forbid, you know, the arrest happens. But not that we want to
no, I think it's
touch wood.
Compliance, like you said, prevention is better than cure.
Absolutely.
And I think those who want to comply the most feel at most risk, though, I suppose. So, I mean, compliance is always a bit of a moving target because there are obviously things that we're just continuously updating. So, yeah.
Yeah, and unfortunately also for those that work for brands that are out there, it's like with Department of Labor audits, it's like with UIF audits. It's far easier for them to come to compliant businesses where it's easy to find than to deal with the kind of the non-compliant. So it does mean that very often bigger, more public businesses are likely to face inspection because they're easy to find. And then, of course, the bigger we are, even though we try and be as meticulous as we can be, we often have, there's clipsies that happen with, paperwork that isn't properly filed, or somebody's left and didn't do what they were supposed to do. So that's why what I would just urge, given where we are, is just take the opportunity to do a little compliance check of those foreign nationals, and just so that you've got your ducks in a row, so that God forbid something happens, you are ready, and you've got everything in place. If I can just leave you with one thing, obviously, and we'll pick this up in the next session, is that one of the things is to know your rights, of course, but like anything, politeness and cooperation go a long way in avoiding the strong arm tactics that very often come in situations like that. So we'll definitely tackle that. So I've made the notes, and Lisa, I'm sure you have as well.
Yes.
And then we can also just review some of the questions that have come through. I think you said there were a couple you wanted to reserve. We can chat about those, so we can make sure that we really tailor the next session as well.
Natalie, I'm going to allow one last question to Laurentia, and then any other questions that's in the chat box, we will make sure that either it's addressed in part 2, instead of let us answering it through email or through messages. Send your questions now in the chat box, and we will build it into the second webinar, which is on the 12th of November, where we will see you guys then. So Laurentia, you are welcome to ask your question.
Yes, it's actually not a question but a comment. Just my experience on using this number quoted by other people to validate the permit. We got a message back from the department that you need the consent of the person whose permit you are verifying. So obviously, if you don't get their consent, then you've got an issue. So yeah,
thank you for that.
Yeah, just a practicality.
Thank you, Laurentia.
Thank you for that.
Okay.
Natalie, is that?
That's that. So thank you, everybody. I have enjoyed my day with you, and my details are here. They are on the slides, which will be shared, and I look forward to joining you and your colleagues and clients again, just in a couple of weeks' time.
Thank you, Natalie, so much for a truly insightful presentation. You definitely helped us to make sense of many of the complex situations and often grey areas surrounding the employment for foreign nationals. Your guidance and the practical examples during the session was incredibly valuable to both our members and their clients. To our TESD members, thank you for your active participation and engagement through today's session. We extend the invitation for part 2 to you and your clients again. And then a special word of appreciation to our TESD Exco, my colleagues, and then also the colleagues from the CEA and CIFSA. Your presence and ongoing support truly strengthen the collaboration and shared purposes that we have across our associations. It is encouraging to see with the strong interest we had today in this webinar, and that it's keeping our industry informed and compliant. So please join us on the 12th of November for part 2, where we will take the discussion further into the practical application regarding UIF as well, compliance best practices, and then rates from Department of Employment and Labour and SAPS. Thank you once again, Natalie, and thanks for everyone for attending. Have a great day further and keep leading with compliance, collaboration, and progress in our sector.
Thank you. Have a lovely day, everyone, and a good week. Bye-bye.
Bye-bye.